of KZN Act. The royal family had little or no choice but to identify King Misuzulu in the circumstances. So this is how when the allegation is made that the meeting of the 14th of May 2021 in the review application was dictated upon to the members of the royal family. This is evidence that it was in fact dictated upon, because there was a principle Prince Mangosuthu Buthelezi worked from, which is that the prince he had identified as the heir was in fact a prince who had to fit the custom that he refers to in paragraph 106, and for which is also referred to in paragraph 109, which is the position the Prince Misuzulu Zwelithini's mother, Her Majesty Queen Dlamini took took when she was about to abdicate her position as successor to the late king. So you'll see, my lady, that in the review application, what the applicants are complaining about is that the identification process has not given them the opportunity to deliberate on the candidate or even the candidates. But you'll also see, my lady, that if one refers to the meeting of the 14th of May 2021, there is no reference to this custom to which Prince Mangosuthu Buthelezi refers as a basis on which he holds the view that the ascension to the throne was a foregone conclusion, that the royal family had no wiggle room, or that they had no choice but to identify King Misuzulu Zulu in the circumstances. That meeting, if you look at the minutes of the meeting, there is no reference whatsoever to this particular custom to which he now refers to as the basis on which there is no wiggle room for the royal family to express their views on who should be identified for recognition as king by the president. So there is reasonable prospects of success that the identification process will be found by the royal family, by the review court, as being defective in that it did not give the members of the royal family the opportunity to deliberate on who should be regarded as the heir to the late King, His Majesty, the late King Zwelithini Bhekuzulu. So, my lady, I deal with the issues of who these applicants are. I think that is not any longer necessary for me to do so, because I've submitted that the applicants have standing to bring these applications because they have an interest in the coronation of a king of the Zulus. They are members of the royal family. So if they allege that the identification process has been unlawful, they are entitled to an order, or at least to approach the court to test that belief, and to do it on reasonable grounds that they have set out in both this application and the application in the review court. My lady, I deal with what the role of the royal family is, and in the identification of an heir. And you will see, my lady, if one looks at the provisions of Section 8 of the Traditional and Constitutional Leadership Act, Section 1, subsection 1 of 8 says, when the position of a king or queen is to be filled, or the successor to a principal traditional leader is to be identified, the following process applies. That's mandatory. There is no wiggle room, this word has got a very humorous connotations. There is no wiggle room for interpreting this requirement to be anything else other than a mandatory requirement. The royal family consent, and another sign that this is a mandatory provision, is must. The royal family consent must, within 90 days after the need arises for the position of king or queen or principal traditional leader to be filled, and with due regard to applicable customary law and custom, identify a person who qualifies in terms of customary law and customs to assume the position of king or queen or principal traditional leader, as the case may be, taking into account whether any of the grounds referred to in Section 9(1) or Section 1611H or Section 1614A, C, D, E, and K apply to that person. You will go to if you go to the minutes of the 14th of May 2021, you will not find a discussion around those factors that are referred to in Section 8A1. They are not there. So there was no one asked, does he qualify by virtue of this particular issue? Has he committed any offenses in terms of customary law? Has he done this? Does he live in the area? No one ever went through that list to see whether in fact he qualified. And you will see, my lady, by reference to the Rule 53 record, which they're aware of, that the minister who was responsible for conducting what is referred to as a mediation panel, that sort of tried to mediate the dispute around the succession. The minister advised the president that this particular dispute is such that an investigation is necessary, and that would have fitted properly within the 5 processes that are identified in the judgment of Madondo AJP, which would have been the investigative process and the post-investigative process. Once the dispute demonstrated that it hadn't been resolved, then the president could simply not recognize one person because he preferred that person, or because he was bound by a judgment of the High Court. The role of the president was to ensure, by reference to the provisions of the Act, was to ensure that whatever dispute arose in the royal family about who should be king, that dispute was investigated by him. And that investigation was invested in such a manner that it afforded the opportunity for mediation between the royal family. Because ultimately, what would be the ideal positions for all the royal members of the royal family to agree on a single candidate? That preserves the unity of the kingdom, that preserves the unity of the royal family itself. But in this case, what happened was that the president was fully aware that there was an intractable dispute over the identification process that had been followed. And my lady, that is not to say that Prince Misuzulu Zwelithini does not qualify to have been identified. That's outside the discussion. The discussion is who amongst the royal members of the Zulu royal family was entitled to sit and deliberate on the person identified as a member, as an heir to the late King, His Majesty King Zwelithini Bhekuzulu. So we contend, the applicants contend, that the identification process excluded them, and that's not a miracle, because the allegations that they did not want to be part of these meetings. In fact, they are referred to as rebel royals by Prince Mangosuthu Buthelezi, because he does not really recognize them as members of the royal family in good standing to do what they are doing right now, which is to challenge the process that has been followed in order to identify the particular member that, Prince Misuzulu Zwelithini as the king of the royal family. So you will see, my lady, that the argument advanced in support of an interdict against this coronation taking place is that the coronation would essentially endorse a process that is under legal scrutiny, which the courts are in the present moment trying to determine. And they may determine that the identification process was complied with the law, in which case the recognition also complied, in which case the coronation can go ahead and be finalized. That is a possibility. That is why an interdict is justified in the circumstances, because if the coronation process is completed, then we have problems that cannot be reversed without the warning that Prince Mangosuthu Buthelezi gives in his affidavit to the Madondo court, Madondo AJP court, and is recorded on paragraph 80 of the judgment of Madondo, where Prince Mangosuthu Buthelezi is recorded as having warned in the 2nd, 6th, and 12th respondents answering affidavit that if the situation cannot be curbed, it would result in bloodshed. I mean, coming from a prime minister of the Zulu kingdom, that if the applicants continue to try and assert their rights to be recognized as members of the royal family with the right to identify an heir, that if they continue to do that, this will result in bloodshed is a chilling warning, particularly coming as it does from a man of considerable influence in the national life of this country. So it's not a light warning. It's not a warning that the applicants, being the royals that are regarded as rebels, can take lightly. When they are told that you are not you are not a member of the royal family, or you are a member of the royal family, but you must remember that your mother was not married to His Majesty, your father, and therefore you talk too much about this matter when you are not supposed to be talking too much. That in itself, coming as it does from somebody who appears to have such a strong hold on the life and the stability of a nation as Prince Mangosuthu Buthelezi has, it is a chilling warning that these applicants are dabbling in a dangerous game that will undermine the unity of the nation, that will undermine His Majesty, that will undermine Prince Misuzulu Zwelithini as His Majesty if he's endorsed as such. And that, my lady, is something the applicants are no longer prepared to fear. That is why they've decided they are going to take this matter in all its strides and bring it to the court, because in court they are safe, because in court they will face, as there are, an independent adjudicator who applies the law without fear, favor, or prejudice, and they will get their remedy in court. If the remedy is that they don't have any rights, then that's the remedy that they get. They will accept that. My lady, so we can't take it further than saying that these applicants have a legal interest in the coronation of Prince Misuzulu Zwelithini as king of the Zulu nation. They have a legal interest. The legal interest is that a coronation of a king of a Zulu kingdom must be done lawfully. Because if you go back to how that process was evolved, it evolved through a legally recognized process. If it is found later on in the review court that the coronated king of the Zulus was in fact not identified in accordance with the law or recognized by the president in accordance with the law, that would bring a great embarrassment, or even divide the nation in ways that could result in what Prince Mangosuthu Buthelezi has warned about, bloodshed. So the applicants, as members of the royal family, would want a coronation of a king of the Zulu nation to be done without any legal controversy. And the only platform sorry, my lady.
Sorry, Advocate Masuku.
Thank you.
I would ask that all the people who are logged into the session keep their mics off. The person with ZZM, I don't know whether the noise came from your side, but I would ask that you mute yourself just for safety. ZZM or ZM. Thank you.
My lady, mine is muted, my lady, but it's like...
Yours is muted. It doesn't show it's muted now. Okay. All right.
Those are the wars of virtual hearings, my lady. So I'm glad you've got the patience for such intrusive interruptions. But so my lady, what the applicants are essentially before this court to do is to say to your ladyship, the 13th of August, a king of the Zulu nation will be presented to the world. He will be presented as though he has been appointed to that position lawfully. And yet the court is sitting, determining whether or not that is in fact the case. And we say the applicants have a right to have that question determined first before the endorsement of a coronation event takes place. Even a king must accept that proposition, that if there is questions about the lawfulness of their appointment, a court must determine that before they are sent to the throne. It is not a matter that they can steamroll. It is not a matter that they can force. It is a matter for which the very legitimacy of the Zulu kingdom depends on the lawfulness of the appointment or the ascended king's legitimacy. So we say that the applicants have made a compelling case for the interdict of the coronation of the coronation event to be interdicted, which is scheduled to take place on the 13th of August 2022. My lady, perhaps let me just go through the facts. But before I do that, maybe let me just deal with one aspect that I know will be raised in reply in answer, but I deal with it because we also raise it here in our main address. The first is that this case is not going to be resolved on the basis that on the arguments of whether or not Prince Mangosuthu Buthelezi is a member of the royal family or not. The applicants accept he's a member of the royal family. They define how his membership of the royal family is. And there appears to be notice the irreparable distance in the understanding of where his royalty actually comes from. There is nobody who says that he is not attached to the royal family through Princess Makoko, his mother. So that is not the issue. So this case is not going to be resolved on that question. The question is going to be resolved simply on the basis that the coronation event validates procedures in the appointment process of a king that are under review in terms of the application that is before the court, in which the lawfulness of the identification and recognition process is still under consideration by court. The coronation event ought to stop before these issues are resolved by the court. So we are not fighting over who is a royal member of the family or who is a prime minister of the Zulu kingdom. I think that is accepted generally, although my clients do define the position of prime minister as not giving the prime minister powers that are far above theirs as sons of the kings to which they belong and members of the royal family on that basis. They don't contend that he is not a prime minister of the Zulu nation. They say that he has given himself powers of veto. Essentially, in his affidavit, my lady, you'll see that Prince Mangosuthu Buthelezi takes the view that he alone calls the meeting. He alone determines the agenda. He doesn't have to consult anybody when he does those things. And certainly has not consulted the applicants when he has done things that relate to the Zulu royal family. And they are contesting that because they are saying, and you'll see, my lady, the report of the mediation committee, that it creates a climate of fear in how things are managed in the royal family. That even when his late majesty had died and the late wives of the king wanted the body of the late king to be sent to each palace, the mediation records that they were threatened by Prince Mangosuthu Buthelezi with arrest. He was going to get them arrested for bringing for wanting to mourn the late king's death by having his body brought to the home as customary. The body brought to the palace, and then of course it will leave the palace to the next palace, to the next palace, and to the next palace. So you will see that there is the conflict really, and the court can only be of assistance in moderating the extent to which the power of the prime minister of the Zulu nation appears to be exercised. The applicants have used strong words like dictatorship, and they've pointed out why they've used words like dictatorship. They've used strong words like the strong words that Prince Mangosuthu Buthelezi complains about. But the truth of the matter is that the issue really has to be decided on whether or not the applicants accepted that they are members of the royal family have made out a case that the coronation event should be interdicted and not proceed as scheduled on the 13th of August until the outcome of the review application and the application that is serving before the Supreme Court of Appeal, which implicates the very process of identification. And my lady, just so you are in the you appreciate the other factors which are necessary. It's common cause that there is a conflict in the royal family about the validity of His late Majesty's will.
I saw that.
It's also common cause that that case is pending before the courts. It's also common cause that if the courts invalidate the will of the king, the basis on which the late Queen Her Majesty Mantombi Dlamini Zulu was appointed was that particular will. She was appointed as the successor, and there is a dispute about whether she was a regent or she wasn't a regent. That dispute is not necessary for your leadership to resolve. One must just look at whether what the will of these late majesty, all of them, there are about 3 of them now that are contested. What all of them say, they appoint a successor, not a regent. And there is nowhere in the record that tells us how this regency of Her late Majesty was actually achieved. She does not regard herself as a regent. And we point out that, my lady, if you see in page 7 of our heads of arguments, we attach a letter that Her Majesty wrote to Prince Mangosuthu Buthelezi as Prime Minister of KwaZulu, umntwana wakwaPhindangene, and members of the royal family. And he's addressed them as Your Excellence. He says, successor to His Majesty the King. Then she says, the task that befalls me weighs heavily. After the untimely demise of our king, Isilo Samabandla onke, King Goodwill Zwelithini, the need to fill up the position of the fallen king has arisen. His Majesty the King, during his lifetime and through his last will and testament, bestowed upon me the singular honor to succeed him and assume the role of the Zulu monarchy. I hope that the wishes expressed by His Majesty the King to bestow upon me the privilege of being His Majesty's successor will be welcomed and embraced by your good selves. Whilst I'm humbled by the honor and the wishes of His Majesty, I believe it is to be appropriate and befitting of this great Zulu nation to bestow the honor given to me by His Majesty to my son Umntwana Misuzulu Zulu. In this regard, I implore you to give consideration to appointing Umntwana Misuzulu Zulu as the king in my stead. I am hopeful that Umntwana Misuzulu Zulu will accept this honor and duty with buoyancy. In the event that he does not accede to my wishes and is not appointed, and only in those circumstances shall I oblige with the king's wishes that I should succeed His Majesty. I believe that Umntwana Misuzulu is eminently suitable to assume the position. So Her Majesty herself did not understand her position to be that of a regent. When the president says that she was a regent, she is wrong. When Prince Mangosuthu Buthelezi says she was a regent, he is wrong. Her own understanding of the will is that she was appointed as a successor to the late king. There is a ripple effect to a declaration of invalidity in respect of the king's will that will permeate right through. Now, my lady, you will know that the royal family is entitled to give consideration to whether or not there was fraud committed on the king's will. Because clearly, if there was fraud committed on the king's will, this was intended to influence the succession to the late king as it follows.
Advocate Masuku, may I interrupt you? It's 11:34. I see we've already gone that fast. Well, 11:35. I would like us to take a pause, even if it's for 15 minutes, just for us to refresh the body, our bodies, and then reconnect in 15 minutes. That will be, in my reckoning, 11:50 exactly.
My lady, that is needed. That break is needed, my lady.
We will pick up. Thank you very much. Quarter gents, now we'll pick up at 11:50. Thank you. Everyone is excused. Thank you.
Thank you, my lady.
Judge, before we proceed, my apologies, Mr. Masuku. Judge, may I just recall matter number 24, or should we wait until we have completed with this matter?
No, let's dispose of matter number 24. Okay?
Thank you, Judge. Recalling matter number 24 on the roll, it is case number 36643 of 2022. It is the matter of Unicorn Developers Pty Limited and the City of Tshwane.
May it please the court, my lady. I appear on behalf of the applicant. Thank you for the indulgence, my lady. Mr. Maisela is appearing on behalf of the respondents. We have uploaded a draft order which has also been provided to my lady's registrar, and we will seek that draft order be made in order of court.
May it please the court, my lady. I do confirm, my lady, that my colleague and I had an agreement with how the matter should proceed going forward, my lady.
Thank you very much to both counsel. You're excused. We'll work on the draft order. If there's a need to contact you, we will. Unless if there's nothing controversial, then it should go through. Thank you. You're both excused. Okay, we go back. Thank you very much. Ms. Registrar, we go back to matter number 20, please.
Okay, Judge. Let me recall matter number 20. It is case number 35559 of 2022.
My lady, can I proceed?
Yes, Advocate Masuku.
My lady, I intend to take 15 minutes so that...
I was going to ask how much longer are you going to still push? 15 or 10 minutes?
10 minutes, my prophetic soul.
Okay, all right. Let's do that.
My lady, I just raised and read the letter of the late Queen, Her Majesty Mantombi Mfu of Gadlamini Zulu. That letter, I read it because I wanted to submit, or I submit that letter demonstrates that there is a fundamental error on the basis of which the president recognized Prince Misuzulu Zwelithini, which is that the Queen was in fact a regent. That is also part of what the narrative that is set out in the president's letter, recognizing the narrative includes that she was in fact a regent, and when in fact she wasn't a regent, she was a successor. And her understanding of her position was that she was a successor. My lady, let me just deal briefly with the requirements of an interdict. My lady, they are tried, and I need not bother your ladyship with rehashing them. As far as the prima facie right to have the coronation event interdicted is concerned, the applicants have made out a prima facie case, and because they've demonstrated that they have a prima facie right to have the identification and recognition review application heard and disposed of prior to the coronation event being allowed. My lady, there is no alternative remedy other than the court process itself. You would have seen, my lady, in the intensity in the papers around the dispute are such that it would be difficult to have a solution outside the court speaking and interdicting that particular process. So, my lady, it would be appropriate to issue this interdict because the applicants, they have no alternative remedy really, because as you would have seen, Prince Mangosuthu Buthelezi says that they could have approached the Prime Minister himself, and they could have approached members of the royal family to ask for a postponement. But that obviously is not a remedy that would stop the coronation on the basis of law, not on the basis of some favor extended to them. And what they are setting here is a legal right to have a coronation that complies with the law. My lady, the irreparable harm is evident. The members of the royal family are about to witness the presentation to the Zulu nation and to the world at large of a king whose appointment is a subject of a review application, and that, my lady, should not be done. It caused great embarrassment to the royal family, to His Majesty himself, because in the event that the court declares that he's not been appointed in terms of the law. And we suggest that the irreparable harm, my lady, is also just divisions in the royal family, intractable divisions in the royal family. The stopping of the coronation might just provide an opportunity for the members of the royal family to reflect a little bit more about what role they should play in order to give to the Zulu nation a king or a king they agree on, or in accordance with the process that is lawful. As the matter currently stands, there is clear danger that I've referred to, for which I quote from the affidavit of Prince Mangosuthu Buthelezi, or at least the judgment, quoting from Prince Mangosuthu Buthelezi, of bloodshed if the issues are not resolved lawfully. The balance of convenience, my lady, it would be no harm whatsoever to the applicants, to the respondents, if the interdict is granted. They claim none. They claim no prejudice whatsoever. They don't say what prejudice they would suffer if this interdict is granted. My lady, briefly, let me deal with the issue of the application to strike out the paragraphs referred to in the counter application. My lady, you would have seen that my
paragraph 109.
109 in the founding affidavit, my lady. You would have seen, my lady, that the basis for wanting those allegations struck out is not that they are not true. And that's fundamental. The members of the royal family have raised it with the mediation panel. It's recorded amply and amplified in the mediation panel that members of the royal family believe this is the situation they are faced with. If there's to be a strikeout, it must be on the basis that these allegations are being made for the first time. But they are made in the media. They've been a subject of front page reporting in the newspapers. They are allegations that are not being made in order to devalue His Majesty, Prince Misuzulu Zwelithini. They are allegations which are made to amplify the right of the royal family to vet the candidates they are presented with for presentation to the president for recognition as king of the Zulu nation. Now, if this matter was dealt with within the royal family, we wouldn't know any of these things, because the royal family would have protected this information from coming out. But the process followed was so arbitrary that members of the royal family are speaking everywhere about these issues as true. They say it's true. But one of the things that come out from the rebuttal, particularly of Prince Mangosuthu Buthelezi, is not that these allegations are true. We don't present them as true allegations. We present them as allegations which the royal family is entitled, when they determine the fitness for office of any candidate, they will have to decide those questions. If they are true, my lady, as members of the royal family they believe they are, then, my lady, they are relevant to the question in the review application. Has the identification process afforded the applicants the opportunity to test the fitness of the candidate presented as a rightful heir to the position of king of the Zulu nation? And so we submit, my lady, that there is no basis on which they should be struck out. They are unfortunate. They are chilling. They are not the kind of allegations one should make lightly, and we accept the criticism that they're unkind. But here is what the applicants are saying: the Zulu royal throne is above all. The sanctity and sacredness of that throne demands that they act the way they have. Their continuous exclusion from Zulu royal matters has made them determined. In fact, my lady, the first applicant says determined to death if it means that they do so to protect the Zulu throne. Now we need a court to give stability to the to an environment that is infected with this kind of things. My lady, I've dealt with the complaints of
Thank you.
my learned friends relating to the urgency of the matter. I contend it is urgent. I also contend, my lady, that the court is properly seized with the application. The complaint about jurisdiction is without any grounds. My lady, I accept the criticisms of my learned friends, and these are lawyers now talking, and these are not our clients. I accept that the relief that we seek may well be criticized for inelegance. We are happy to walk away with the order interdicting the commencement of the interdicting the coronation event of the 13th of August 2022. I don't know that it is useful for me to debate what I also see my learned friends have raised, the fact that a declaratory order that King Misuzulu is not to be regarded as lawfully appointed it might preempt the review application. That's the very reason why there is a review application. It is to test that. So I accept that, even though I say pending the determination. So it's not a statement of finality to say that, but yes, I do accept that the criticisms that my learned friend give are valid. My lady, as far as paragraph 4.2 is concerned, interdicting Prince Mangosuthu Buthelezi from threatening the applicants and members of the family who oppose the recognition of Prince Misuzulu with violence. My lady, we have said, I mean, the use of words like bloodshed, and there are other essentially, my lady, when you read the affidavit of Prince Mangosuthu Buthelezi, it is clear that he regards the applicants as rebel royals who are spoiling for a fight in circumstances where they are not entitled to do so. If the position he holds is such that those remarks that they are exposed to amount to a threat, because essentially they are being told you shouldn't say these things because, in fact, your membership of the royal family is questionable. You don't have standing to be raising these issues. And that, my lady, has got the potential of, but we don't mind if your ladyship in your discretion decides that's not an order well made. It's not. We won't follow. We won't consider that to be a problem. My lady, the president and the minister of corporate governance, they oppose the interdict on the basis that we haven't cited the council, but the interdict we seek is based on them offering this support to Prince Misuzulu Zwelithini on the basis that he is the king. Because we challenge the title that that he is the king. The applicants challenged that title. So we say no expenditure of government should be spent on coronation, of coronating a king whose recognition and identification is a subject of a review.
Okay, Advocate Masuku, I hear you. I'm going to, I have a couple of questions for you.
Thank you.
The first thing is this. I don't know why we are here today on an urgent application to hold a coronation process that is around the bend, when there are a number of dates that are significant in the evolving of the entire process that would lead to the coronation that have been left unexplained in your presentation and submissions. They're not dealt with even in your affidavit. And I'm referring to the dates since the Pietermaritzburg High Court handed down the decision, where it says very clearly that nobody could have been a better contender to the title, to the throne, than the first respondent. And then there was that was the 12th of March, if I remember. And then on the 16th of March, there was the recognition letter from the office of the president. I don't hear what actually happened. Why are we here today talking about urgency when all of these developments, all of these processes unraveled as we go along? Where were the applicants? So that today we're talking about an urgent application. That's the first thing. The second thing that I don't understand, by what law do we halt an administrative decision because it's being attacked from various fora for whatever reason? Assuming that it were to be true that whatever happened on the 14th of May holds no validity for whatever defects and whatever accusations or allegations are made as to what actually happened there. The first thing is this: there are decisions of superior court that are binding on this court, telling it very clearly that it doesn't matter from what angle an administrative decision is attacked, it's valid, it's alive, and it's operational. I don't understand by what law I'm now going to simply extricate myself from those decisions of the superior courts. I'd like you to just start with a question of urgency, because that's where the real issue is for me.
Thank you, my lady. Firstly, on the issue of urgency, my lady, the announcement of the date of the 13th of August as the date on which the coronation should take place was around the 25th of June. That was the announcement when that was happening. Previously, what had happened is that when a date for the coronation had been raised or announced, what our instructing attorney did was he was instructed to write a letter to the president who had accepted that invitation to the coronation, to ask him to not attend the coronation meeting, the coronation, on the basis that this application to review and set aside his decision was pending before the courts. His answer was that he's got no power to arrange a coronation. He doesn't have the authority to do so. But that letter was also copied, was sent to Prince Mangosuthu Buthelezi. He was aware of it. Now, my lady, once the first date that was set for the coronation hearing fell off, because then there was subsequent announcement that the date which had been set out, I think it was in July, was no longer going to take place because of the floods, the consequences of the floods, and there was a focus by the province on the floods that had taken place, devastating floods that had taken place. That took away that would not have triggered the coronation aspect, because if there was no date on which the coronation event was to take place, it would not be there wouldn't be any basis to bring an application to stop a coronation, because there is no coronation taking place. In fact, when the applicant brought a similar application in the High Court, he had believed that the coronation event was scheduled to take place on the 3rd of August of last year. 3rd of December last year, and that did not take place. And the judge said, well, that there's no coronation taking place in December. The dates which he suggested, which justified the basis for him coming to court on an urgent basis, and they're not coronation dates. But now the applicants know, they've been told, the whole world has been told, the 13th of August is the date on which the coronation events. They are told this announcement is made around the 25th of June. They immediately put an application together, which is this application. And you will see, my lady, that the application took about 10 days to come up with. And we're here today because that announcement galvanized the agency. It actually created the agency, because without an announcement on the date of the coronation, there would be no basis for us to come to court, because there is no coronation. That's the assumption one must make. But the moment there is a date to it, all the other dates your ladyship refers to prior to that are dates not relevant, because they do not announce the coronation event. The dates it may be the 25th or the 18th, but the applicants got to hear about this coronation event. It's not been denied that it's taking place on the 13th of August. It's now firmly established that the coronation event is taking place on the 13th of August, 2022. And that did not come on the 14th of May when the meeting that took place then, or when the date of the recognition was done. Those two events are subject of the review proceedings. They are rightly before the review court, and the court will decide whether those aspects are reviewable or not. What we're merely saying to your ladyship is this: the coronation event is coming up on the 13th. If it takes place, it completes the cycle of ascendancy. We say prevent it from taking place because the recognition and the identification recognition process are under review in a court. Pending that, the coronation event is essentially also threatened by the review itself. Because, my lady, if the review succeeds right up to the Constitutional Court, right? That coronation event would have been would be of no value, because the coronation can only be done on the basis that there's been a lawful identification and recognition process. So, my lady, the issue of agency really comes as a consequence of the respondents themselves announcing the date for the coronation, and not because of the previous other meetings that took place way before. There is a suggestion that there may have been a peek by the applicants into communication between the president and Prince Misuzulu, Zwelithini, who the president addresses as King Misuzulu, Zwelithini, rightly because of the recognition certificate. Where the discussion of the 13th of August is referred to, clearly the letter was not addressed to the applicants. They would not have known that as way back as June, sometime in June when this communication was made between the two, that the coronation event was the 13th, until there was a formal announcement by the Prime Minister of the Zulu Kingdom. Until there was and you will see, my lady, on the papers, they don't deny that the 13th is in fact a coronation date. So
it is so, because you've referred me to your footnote number 1 in your heads of argument, where you map out the entire process that leads to the coronation of a successor to the throne, and you've set out from A to E. These are all critical steps in the development of what would lead to that final event of the coronation.
That's correct.
I do not understand why where the applicants were, what they were doing. They didn't agree with the identification process. They still didn't apply for an interdict. They could have brought it as part A. When they brought the review proceedings, there is criticism in the papers that they didn't seek an interdict then. The recognition process itself, they didn't do so. We are now here seeking to interdict a coronation, and we are all complaining that it's all about the complaint I'm hearing is that it's around the bend. But what were the applicants doing all along?
No, my lady, the applicants have brought a review proceedings. They seek to review A and B.
I agree. I accept that. It's swept out in the papers.
Yes.
But there was an opportunity there to apply for an interdict in all those proceedings.
No, my lady. I mean, your ladyship would know that the fact that they did not apply for an interdict in A and B, and that A and B is now a subject of the review proceedings in the High Court, does not mean that the coronation, which is the last stage, cannot be stopped. It's in a similar situation where someone builds illegally and builds up to the first story, and they're stopped from building further the third story or third story on the basis that the building authorizations have not come through. So I'm submitting to your ladyship that it's in the same situation where a complainant against a builder who's building illegally can be criticized for not having interdicted the foundation or interdicted the first story, but it is never the law or the basis of the interdict law that when they bring a well-founded application, that the putting up of the roof or the putting up of the third floor continues to violate the foundational issues, that the interdict would be stopped. So my lady would say that it is not a barrier for the applicants. What I submit, my lady, is that your ladyship would consider when the applicants got to hear that the coronation event was taking place, remembering that when they had heard through rumor and the rumor mill that the first coronation event was going to take place on the 3rd of December, they brought an application to try and stop it. That 3rd of December came and went, and there was no coronation event. And so the judge said, no, but these events didn't take place. They are moot. They don't have to be decided. Now we have the right people announcing publicly that there is a coronation that is taking place on the 3rd of August. Even the fact that the coronation committee was announced publicly as existing and carrying out all these activities does not galvanize an interdict. What galvanizes an interdict is that there is an event that Prince Mangosuthu Buthelezi says is a special event in terms of Section 17 of the 17.5 of the KZN Act, which is a special event in terms of which the Premier recognizes the King while he takes the oath that he takes of allegiance to the Republic, the province, and the law and the Constitution and all that. So that is what brings the agency, my lady. There would be, I mean, I understand the criticism that my learned friends try and bring against the bringer, but it's no answer to the proposition I'm putting to you and the facts as they come out. If the announcement was in July, say say on sometime, we say that we heard publicly that the coronation event would take place on the 25th of June. The application to interdict this event came early July. Early July, it was there. So I'm suggesting to your I'm submitting to your ladyship that grounds agency. And if your ladyship briefs us on that, and then of course those are the facts that on which we rely on agency. If that's not agency, then of course that's not agency, and the court would be obliged to deal with it. But my lady, I've addressed you beyond just agency, and I urge your ladyship to deal with the matter beyond the agency issue, because this is for interdictory relief. You have a discretion, my lady, looking at the nature of the case, to consider whether or not it is not just and equitable to grant this order, which would preserve the rights of the applicants to participate in the affairs of the royal kingdom.
Thank you, Mr. Masuku.
The second question, my lady, you asked me was in terms of what law. I am not suggesting, my lady, that the decision on and that's why I considered, albeit vaguely, and I say that now I'm going to be hammered for saying vaguely considered. I considered that the other orders, or the declaratory orders that would, for example, cause that Prince Misuzulu should not be regarded as king, are orders that your ladyship could say, well, they fall squarely within. They
reside with the review court.
With the review court. And if your ladyship didn't give us that and gave us just that order that interdicted the coronation event, we would be satisfied with it.
Thank you, Mr. Masuku. I'm going to invite. Yes.
Those are our submissions.
Thank you.
For the moment.
Thank you. You're excused for now. I'm going to invite the respondents now.
Thank you, my lady. I intend to address 5 topics, and very briefly, I must say.
First, second, and 14th respondents. Mr. Madonsela?
Yes.
Thank you.
It is a striking feature of this application that the applicants have made out a very convincing case, except only in reply. And that is not the right place to make out a case. But even that case that they make out in reply is has got its own difficulties, which I will point out in a moment. So I intend then to deal with the agency first, because that agency has not been established in the application papers. I'll also deal with certain incompetent reliefs, and I don't understand if, I'm not sure if defense concedes some of those lists, but I'll touch on them very briefly.
I think a concession was made as to the appropriateness of seeking some of the orders, but you're still at liberty to respond to those.
I'll be very brief on those ones, just to highlight where we deal with them exhaustively in our papers. And then I'll deal very briefly with the case that the applicants has made out in the founding papers, because it is in the founding papers that the applicants must make out its case for the interdictory reliefs which they seek. I shall demonstrate that that case is a weak case and that has no prospect of success, and with the result that the court does not even have to engage with the balance of convenience because the case is just so poorly made. And I will also deal briefly with why the other requirements of the interdict have not been met. Those are and I'll deal with the strikeout application finally. Those are the topics that I wish to address my lady on. First, on agency. We make the point in our heads of argument that there's been a brazen disregard of the uniform rules of court in relation to the absence of averments in the founding affidavit motivating why the matter should be heard as one of agency. And there's been total non-compliance with provisions of Rule 612B, which require that an applicant in court must set out explicitly the circumstances which render the matter urgent and why the applicants cannot be afforded substantial redress in due course. Now, my lady, we have pointed out the judgment in paper in our heads of argument in which the similar situation occurred, where there was an appointment and identification, coronation of a king. The matter went all the way to the SCN Constitutional Court. Reviewing court set aside the whole appointment and remitted the matter back to the royal family. That was a substantial redress in due course. That case is an illustration that there is in the reviewing court a substantial redress in due course in the review, with the result that there is no need for this court to grant the interdict that is sought here. But our complaint and our submission is that it is not just for the court to work out from its own deduction whether the applicant will have a substantial redress in due course. It is the applicant who must state in the affidavit explicitly why it cannot be accorded substantial redress in due course. The applicant does not even do that. You can go through the entire affidavit. You will not find those averments. There's just simply non-compliance with the rules of this court in relation to agency in this matter. And we submit, my lady, that my letter friends hope to create or to make a comparison between the interdict granted in building environment and implementation of contract is inapposite, because the reason why courts do grant interdicts in relation to implementation of contracts in tender disputes, as well as stopping a building from being built, is because in contractual law, there is a possibility for an argument that can be made in the reviewing court that we can no longer turn the clock back because the contract has already been implemented to finality. So the court does that in order to preserve the status quo pending the review. Here, there is no argument, there can be no argument that the clock cannot be turned back. The judgment in paper is actually an illustration that a clock can be turned back in due course in the review. So my lady will say that there has been brazen disregard of the rules of court, and there has been no compliance with the uniform rules of court in relation to motivation and application for the dispensing with the rules of court, and for the matter to jump in the queue ahead of other matters and be heard in urgent court. It is no answer to say, as the applicants say, that well, you have given you enough time to file the papers. The reason why the court insists on compliance with Rule 612B is because the court has to make a judgment call in the allocation of judicial resources to determine who how the matters should be allocated, and what priority should be given to this or that other matter. It is for the applicant to satisfy the court that its case is one that requires that it should be given priority above all other matters on the court roll. So my lady will say that there's been just absolute non-compliance with the rules in this case. And on that basis alone, the court should strike out the matter. But secondly, my lord, you would have seen in the founding affidavit at paragraph 101 to 103, its case lines follow 6, page 27, that the application, it's 001 follow 1, page 61, that the founding affidavit and the motivation for agency was the false assertion that the president had not delivered a review record. It was made at length at paragraph 102. It was said that this matter is urgent because the president and the first and second respondent have not are litigating in the review proceedings at leisure. They have not delivered a review record, and therefore they are going around saying that the first respondent is the king, and they can't wait. That's why this agency is justified. That was a justification for the agency. Now, my lord, it turned out from the president's response that which you will find, my lady, at folio 6, page 27. So, it's actually the reply. It's paragraph 52 of that reply. You'll see there that the applicant concedes in the reply that there was a review record that was delivered already on the 10th of May. And it was the applicants who did not advance the review in any manner by delivering a supplementary affidavit. So, my lady, it was false and it was wrong for the applicant to come to this court on the basis that, and justify agency on the basis that there was no review record when there was already in May, and they had done nothing from that time to advance the review proceedings. Of course, my lady, the review record revealed that the minutes of the 14th of May were also part of that record, which rendered it unnecessary for the first and second respondent to deliver their own record because the reliance is placed on the 14th May meeting. But you will see, my lady, at case lines folio 4, page 24, my lady, that the paragraph 42 of Buthelezi's answer affidavit indicates that the only time that they were engaged on the advancing the review or filing the record was only on the 13th of July, last week, when the papers in this application were being exchanged. So, my lord, we say that the applicants have approached the court for agency on a false premise that there was no review court when there was one. And it is them, in fact, who have litigated at leisure in relation to the review by not filing a record in time, a supplementary affidavit, and advancing the review in the way that they may deem fit. So, my lord, we say that it was incorrect. It was an incorrect premise that the applicant approached the court on agency. There was, my lord, the record indicates that there was indication from the first or second respondent as early as in March, to be precise, 17 March, where the applicants were informed in the world as well, in a press statement, that there is a steering committee or coronation committee which was going to be set up to make arrangements for the coronation. It is also true that the applicants approached the president to seek an undertaking that the coronation will not take place. On the 22nd of April, the president responds, and he tells the applicants, I'm not the one who's responsible for arranging the coronation. That matter is not governed by national legislation. He tells them in April, and then he also advises them to go and talk to the premier about the undertakings, as well as the Zulu family. What is absent from the founding affidavit is what the applicants did with that advice from the president, who told them in no uncertain terms that they must go to the premier. They did not go to the premier. And as it turns out, Section 17.5 places foursquare the responsibility of organizing a coronation on the premier's office. That's the right person who should have been approached for any undertaking and for any discussion or negotiations about whether the coronation should take place or not. That in these papers, and even in reply, there is not even an attempt by the applicants to indicate whether they have ever approached the premier. But there is an attempt to try and explain away some correspondence between the applicants and the first respondent. And that correspondence indicates that the applicants are even prepared to go to the extent of lying about what they did in correspondence with the second respondent. You'll see, my lady, this lie and the attempt to mislead this court about the correspondence that took place at case lines folio 7, page 62.
1 second. Page 62.
Yes, it's a letter that is put up by the applicants in reply in an effort to explain what they did in order to approach the Zulu family and the second respondent in negotiating why the coronation should take place. Now, my lady, the letter, which is PM1, is a letter dated 20 January 2022. It is put up in reply by the applicants in order to demonstrate that they did communicate with the Prime Minister, Traditional Prime Minister, the first respondent, to talk about the coronation. But in its terms, as you can see, my lady, it deals with a totally different matter. It deals with the current commemoration event of Berkeley Officer, which took place in January this year, and in relation to which the applicant lodged an application in the High Court, and that application was dismissed. It is not an answer to why the applicants sat idle from April when the president told them to approach the premier and the second respondent. It is in fact a misleading statement to say that they have done so. In fact, if I can just take you to the replying affidavit where they deal with this. You'll find that you said that in our heads of argument at paragraph 11 of our heads of argument, follow 13-8. It's paragraph 29 and 30 of the replying affidavit. The Butchelis is replying affidavit. You will find this, my lady, at .007, follow case lines 007, paragraph 12. They say that from page 11, I addressed a letter to Prince Mbonisi Bekithemba seeking clarity on the public announcement of a pending coronation event. But the letter...
Paragraph 11.
Yes, if you look at follow 007, page 11, Start of paragraph. Yes, start of paragraph 29.
Okay.
Or towards the end of paragraph 29, right at the bottom.
Yes, I'm reading from page 12.
Yes, it says that the last two lines, I addressed a letter. This is in response to the assertion by Chelezi that they have done nothing to approach him from the time that the president had indicated that they must approach the premier or the traditional prime minister. He says, I addressed a letter to Prince Mbonisi Bekithemba seeking clarity on the public announcement of a pending coronation event. And Prince Mbonisi Bekithemba did not respond to the letter, which if he had done, would have averted the hastily prepared preparation, I think, of the application. And he says, I attach letter PM1. And this is the letter which I've drawn to the attention of the court, that it does not actually deal with that issue. It deals with a completely different event of January, which led to the application in the case at the court, which application was dismissed by Kuhn already in January. So, my lady, there was no attempt to explain why the applicant did nothing between April, when the president advised him, up until this application was lodged in July, 3 months after the fact. In fact, the explanation that is given is actually a complete attempt at misleading the court. And we make the point, my lady, in our heads of argument that if litigation history is anything to go by, the applicant is simply abusing the court by pushing the court to the limits to deal with very, very weighty matters and very extensive issues which have taken place and have been dealt with at length in 3 applications, at least in the High Court, in the case in the High Court, in a rush. It is simply unfair to the courts, unfair to the respondents to be put to all this pleasure to put up the papers at short notice. This must be viewed against the fact that, as we say, at paragraph 14, as the answering affidavit says, at paragraph 14.9, it's 4004, case land, page 16. That the first applicant, and I focus on first applicant, my lady, because he's the protagonist in this matter, and in fact, we have not seen any supporting affidavits from the other applicants in this case. The first applicant was a party to the case at end proceedings. He was joined as a party, and he did not at any stage raise all the issues he's raising now in these proceedings. And it is only now, after the fact, that the applicant is now entering the fray, as it were. 2 of his previous applications, which were abusively brought at very short notice, short time frames, were all dismissed by the case of the end court. We are now on the 3rd row of cases that the applicant is doing, in the circumstances that he is doing now, when he is pushing the courts to the limits to hear the matter. So, my lady, we submit that there's been no agency established in this case, and there's been, in fact, undue delay in bringing the application. And the Coronation Committee has done its work. Now the President has confirmed that he's available for the 13th of August. And it will be no train smash if the coronation event occurs, because the reviewing court can even grant an alternative remedy and a satisfactory remedy in due course if there's success in the applicants in the review. So, my lady, we submit that the case for agency has not been made out. I then deal, my lady, very briefly, as I said, with what I call the incompetent reliefs. I do not really want to spend a lot of time on this aspect. All I wish to...
Okay, the gentleman with, yes, please also close your video feed. Okay, the gentleman with mic The gentleman with the video feed, thank you. Okay.
I just wanted to make a few points in relation to incompetent reliefs. I will just deal with the issue on the basis that I can draw the attention of the court to folio 4, case lines, folio 4 at page 11.
I'm right there.
At paragraph 11.1 to 11.5, we analyze the reliefs that the applicants seek. And it's essentially, if the concession is anything to go by, then it will affect paragraphs 4.1, which is a declaratory relief. It will affect paragraph 4.3, which is an order sought against Cockcher, which we say the court cannot interdict or make a declaration on because it's all matters which have already happened. And then it will affect paragraph 4.5 and 4.8 because the Coronation Committee, as we say, is an ephemeral body, is an advisory body, and therefore there can really be no interdict against it to give advice. It will also affect paragraph 4.6 and paragraph 4.9, which again are the orders directed at the Coronation Committee. And it will also affect paragraph 4.11, which is strangely an order directed at Prince Zwelithini Zulu, who is a spokesperson of the royal family. The interdict that is being sought against him is to stop talking on behalf of the royal family and the king. And we've made the point in our affidavit, in the affidavit of the deponent, that the court cannot interdict the Prince Zwelithini Zulu from effectively performing his duties under the employment contract. So, my lady, if I understood my friend to making a concession, I just want to make clear that those are the reliefs which will be affected by the concession that my friend makes. But otherwise, those reliefs would, for the applicant to succeed in making making out a case for that relief, and for the court to grant that relief, there has to be a clear right set out in the founding papers. And no case has been made out in relation to all of those respondents in the founding papers, and they make out the case there in paragraph 11. So I thought, my lord, I should just deal with that aspect. Unless if my little friend withdraws the concession in relation to those aspects of the case, then I can deal with it in a refresher argument if the court will allow me to do so. Finally, my lord, that I can move on to the next aspect, and I deal with the case made out for the interdict. The founding papers give us a clue of what the review case is all about, and it seems to be focused on two aspects in our submission. The first is the allegation that the identification of the first respondent is flawed because it flew from the will which is allegedly fraudulent. That's the first aspect that we will claim from the founding affidavit. You will see these allegations made out in the founding affidavit at paragraph 82 to paragraph 89.
I saw.
And we just wish to make 4 points to illustrate how weak that argument is and why the court should not grant an interdict based on that application. The first point is one that I've already made, that the first applicant, Prince Mbonisi, was a party to the proceedings in the case at High Court where that issue arose forcefully, and he did not participate in those proceedings. And he cannot now, in our submission, ride over an appeal by the princesses who raised the will issue when he did not participate in those proceedings, and seek an interdict in this court on the basis of an application he took no interest in. The second point we wish to make is that in making an allegation of fraud, the applicant makes reference to proceedings in the High Court, which were brought by Judge Jerome Ngwenya. And those allegations of fraud are dealt with exhaustively in the application brought by Mr. Jerome Ngwenya in his application. The applicant does not disclose what those papers say. He just simply gives a gloss at those application papers. Yet they have an important consideration on whether the allegations of fraud have got any merit at all.
As set out in your answering affidavit.
Answering affidavit. So my lady will say there's been non-disclosure in relation to that issue, and if regard is had to in particular, the confirmatory affidavit of Mr. Chlobera, who says under oath that the will by the late king was executed in his presence and by the late king, and therefore is not fraudulent, puts paid that all argument about allegations of fraud. The third point we wish to make about this is that in any event, the allegations of fraud are a red herring in our submission, because they have been overtaken by the decision of the royal family at its meeting of the 30th of March 2021. I would like to take my lady to that meeting because it's important. Because Malala Fan says in his argument today, well, it's not clear whether the late Queen was the regent or not.
The contested 14 May 2001 meeting.
It's
2021 meeting.
It's the 30th March meeting, not the contested one.
Oh, 30th. Oh, the 30th.
Yes, you will find that those minutes at folio 4, paragraph 110. But maybe before my lady goes there, can I ask my lady to go to folio 4, page 39? That is the answering affidavit of His Majesty Prince Mangosuthu Buthelezi, or His Royal Highness. And I'll ask the court to take note of paragraph 92 of that affidavit.
I'm right there.
It talks about the reading of the late king's will in the first sentence. And then he says, with reference to the meeting of the 24th of March, discussions then proceeded to consider the appointment of the regent. And the name of Prince Mbonisi Zulu, the first applicant in this case, was raised as regent, but was objected to by members of the royal family. However, it was decided the matter be deferred for a later meeting on 30 March 2021. Now, at the meeting of 2021, the late Queen was identified by the Zulu royal family to be the regent in accordance with Section 30, read with Section 17 of the KZN Act. And I annex here to the minutes of the 30th of March. Now, those minutes are the ones that appear at page folio 4, page 1110. And I would like the court to have regard to folio 4, page 111. Unfortunately, my lady, we indicated that because of time constraints, these minutes are in Misuzulu. And I hoped that my lady can bear with us in this regard because of the time constraints under which we had to prepare the application. The translation could not be made for the court's benefit.
Okay, I read the minutes, Mr. Madonson.
Okay, thank you, Malady. I was hoping that Malady, I would like Malady to draw to attention to the members of the people who were present at the meeting, which you'll find at 111 and item 3 of the minutes.
Okay.
It's item number 6. It's Mtwana Mbizulu, Ekwezi. Now, it is common cause, and my learned friends will confirm that reference to Mbizulu is Mbonisi Zulu, and Mtwana was Ekwezi, endlini yaseKwezi, is reference to the first applicant in this case. The point we are making is that in these papers and in the minutes which the applicant did not see fit to put up, but were only put up by the respondents in answer, it transpires that it is clear from the minutes that the first applicant was present at the meeting and that he participated in the meeting. And can I ask Madam to go to page 114, follow 4, page 114.
Yes.
It is clear from the bullet point number 2 that Mtwana waseKwezi, that is the first applicant, ubuze ukuthi kuzoba isikhathi esingakanani kulindiwe futhi kungekho okwenziwayo ngesihlalo. He was there in that meeting. He was participating in that meeting. And ultimately, once the regent, the late queen, would have been appointed by the Zulu royal family to take over as the regent, a committee was set up to assist the late queen in her role, in her new role as the regent. One of the members of that committee, it appears later in the minutes at page 115, was in fact the first applicant. Is referred to at page 115 in item last bullet point under A. Mbonisi Bekithemba. That's the first applicant. One of the committee members to assist the Queen. It cannot lie in the mouth of the first applicant to say he has never the second respondent, Prince Buthelezi, has been hijacking meetings. He's been part of these meetings. He's been participating in these meetings, but he sees fit not to disclose it in this court when he brings this agent application. And when he's confronted with this application, with these minutes, he turns around in his reply and says, I can't even recall what I was in that meeting. Now, how should the court deal with this issue, with the conduct of the applicant in rushing to court, not putting up full facts around the issues he raises in this court, and then turning around and reply and say, I can't remember. This, my lady, we submit suggests that the fraud allegation is simply a red herring. A royal family meeting in any event took over the hurdles, decided in a meeting attended by the first applicant to identify the late king as the regent. So you can dance and dance and dance about the will, but the fact of the matter is that it was subsumed by the decision of the royal family, which decided that it will appoint the late king as the regent. Unfortunately, of course, before the president could simply implement the decision through a statutory process of issuing a recognition letter or an appointment letter or a certificate letter, she died 29 days later, on 29th of April. But the fact of the matter is that in terms of the royal family decision and the Zulu custom, a regent had been appointed by the royal family. And the first applicant was present in that meeting. The minutes disclose this. Finally, the issue of whether the late king was a regent or a successor to the king is again a red herring. And whether the will resolve that issue is red herring. We have put up, my lady, the late king's will, an earlier will, which he executed in 2014. Which will, my lady, is not challenged and is unimpeachable. That will, we say in the affidavit, and I can take, my lady, if it's necessary. That will is exactly the same will in relation to issues relating to the success to the throne. Let us assume for a moment that there was something wrong with the will, something that we also dispute in any event. Let's assume for a moment that there was something wrong with the 2016 will, which the princesses and the applicant is challenging or impugning in either these proceedings, the SCA, or in the case of end proceedings. To what end will that be if there is an alien will in exactly the same terms as the will that is impeached? The fact of the matter is that that will, the alien will, be revived. And insofar as the issue of succession, it will prevail. And it does demonstrate unambiguously that the king had in his mind all the time that the successor should come from the royal palace of Kwakangela Mankenga. That was the king's decision. So it's a red herring really to really talk about the fraud allegations and to make them recklessly in this court in circumstances where the applicant does not disclose the true facts, which are known to him, because he refers to the Jerome Gwenya application and he does not disclose what that application says. So we submit, my lord, we have made out a clear case in response to this application that puts to considerable doubt the prospects of success of the applicants in the review, if their application is at all based on the fraud allegations.
Yes, Mr. Madonsela. How much longer are we going to take?
I'm just finalizing now, my lady. I propose the meeting of the 14th of May. Once again, my lady, there has been non-disclosure of the minutes of this meeting. Why does the applicant approach this court on the basis that it is disputing a minute of 14th May and does not even care to put up those minutes in its founding, together with its founding papers? It only had to take the respondents to dig out from the records in the case in High Court to put up the minutes of the 14th of May, which the applicant relies on in order to establish or to try and establish a clear prima facie case in the review. And we make the point again and again, Marita, that the applicant must be taken to have been aware of the existence of these minutes, because these minutes were a debate, part of a huge debate between the parties in the case at end court. And as we have demonstrated, the first applicant was part of that litigation. He knew about those minutes. And it does not disclose them in this court when it brings an urgent application. When we do then disclose the application, and I would like my lady to go to folio 4, page 135, where the minutes are put up. It is clear from the minutes, clear from the minutes put up by the respondents, that at paragraph 3 of the minutes, page 136, the first item on the agenda were apologies. A point made out in the answer affidavit. The first person tendered an apology in that meeting was none other than the first applicant, Prince Mbonisi Bekithemba. Now he does not, and also, my lady, if you go down the pages, I think it's the next page, page 141. There is a list of 140 members of the royal family who were present at that meeting that is put up together with the papers. The list, my lady, starts at pages 141 all the way.
Show the list, Advocate Madonsela.
140 members. Why should the 140 members of the royal family be held at ransom by the applicants in this case? One of whom, the first applicant, did not attend the meeting, tendered an apology, and then turns around now to nitpick and say this and that other thing about the happenings of the meeting, which he elected not to attend. And not only that, he does not deal with this aspect of the case in the founding affidavit to set up what his issues are, or what his issues were with the meeting of the 14th of May. And what do we do, my lady, with the lie again by the first applicant? When he brought this application, justifying this application, at page 001 in the founding affidavit, page 30, when he said to this court, there could be no identification of the king during the period of mourning and before certain rituals could take place. He states this in the founding papers at paragraph 30. It's folio 001, page 30-30. Says, not, I point out that in terms of the Zulu customs and traditions, prior to calling the Zulu royal family to a meeting in which a person is identified and selected to serve the Zulu king as its king, a series of sacred rituals and ceremonies must be performed. And the key ones are Kupoloka Syria, then it goes on and on and on to say what the rituals are. What he does not say in this founding affidavit is what he has been party to. And can I please ask my lady then to go to the minutes which we have put up, which you will see, my lady. Note of yours. There were meetings of the 5th of May, my lady, which we referred to in our heads of documentation. I just let me ask to indulge us to find the cross-reference. It's at case lines 004, page 47. It's paragraph 115. You'll see, my lady, in the minutes of the meeting, which are referred to in paragraph 115 of the paragraph of the answering affidavit, it's PMB 21, which are to be found at uh, 004, page 152. That, in fact, on the 5th of May, long before these rituals that the applicants are talking about could take place, the applicants were already involved in meetings in which they purported to identify the key. And those minutes are set out, but I won't take minutes to the because of time. But those minutes indicate at page 404, page 153, that Prince Mbonisi was one of the first person indicated as an attendee in that meeting, albeit that the meeting was attended by 15 people. Now, my lady, this court has been lied to by the applicants. There's been non-disclosure of very relevant matters and meetings held by the applicants. It cannot, in the light of all these meetings, be suggested, which the meetings, by the way, which the applicant, the first applicant himself attended, cannot be suggested in the absence of the recorder in these meetings that the applicants, or that the first respondent, the second respondent, Mbonisi Bekithemba, was hijacking, manipulating, bulldozing, dictating on the members of the royal family. There were 140 princes and princesses in those meetings who attended those meetings. The record is clear. There's never been any one of them who has complained to anyone about being harassed.
It's now 6 minutes past 1. Are you about to wrap up?
Can I just wrap up, my lady, and say that there has been an attempt by the applicant in various portions of the answering of the replying affidavit to resuscitate certain of the complaints or the queries they have about the identified king in terms of the meeting of the 15th of May or 14th of May. All of those matters the court simply must ignore. They relate particularly to reference to the mediation report. And I can take you, Malay, to various paragraphs of the mediation report, but I think because of time I will not do so. They are set out in paragraph 64, 65, 76, 163, 161 of the replying affidavit, where wholly new matters based on the mediation report have been raised now. The applicants have not, or the respondents have not had a chance to deal with those issues. Had they been dealt with upfront in the founding affidavit, the respondents would have exhaustively dealt with those issues. It is simply unfair that the applicant should put up on the last day of the last but one day of the hearing of this matter a whole host of replying affidavit dealing with new matters in circumstances where the respondents are in no position to deal with those issues. And Malady, we just submit that the court should simply ignore the reference to the mediation report, which the applicants put so much to. They knew of the record, and it's now conceded. They knew of the record. The mediation report was there in the review record. They've taken it from the review record. It was there from May. They should have made reference to it in the founding affidavit if they sought to lie on it. They can't lie on it now. Malady, the case of the strikeout application, I've made it out very briefly in the heads of the argument. I don't want to deal with it at length. It was wrong. It was wrong for the applicant to make allegations of incest about the first respondent in this case. And when given an answer, when dealing with paragraph 109, you remember, my lady, the allegation was that the applicant committed incest against his own sisters of Royal Kangalamakega. He then gives an answer, a complete answer to that allegation. He says, I've got 3 sisters. 2 of them don't have children. 1 of them has a child with the late king of the Bapedi. What are you talking about? Then they turn around in the reply after them. They say, no, actually, we are not saying that. No, the child we're talking about is a child which was born out of the mother's, father's, sister's, brother's, sister's, cousin, whatever the issue is. How are we supposed to respond to that? How is the reigning king, the first respondent, supposed to respond meaningfully and pointedly to a serious allegation made against him, which is now becoming a moving target because it's now being suggested that, no, actually, we made a mistake. We didn't mean the sister in your family. We mean the brothers, sisters, father, sister, whatever the position is in the replying affidavit. It's simply unfair. It was not, in fact, what makes it even more necessary to strike this application out as scandalous is because the applicant themselves, at paragraph 17 of the replying affidavit to the king's affidavit, they say themselves, we do not even believe in the truth of these allegations. But these are the allegations which are said by people, and many people in KwaZulu and in South Africa believe that the applicant is a drunkard. Now, why should the applicants peddle rumors before this court and then claim that this issue is now in the public media? It is them who put them in the public media. In response to this, must be struck out, my lord. We submitted the application to strike out for lack of agency, and if the court was minded to hear the matter, it should simply dismiss it with cause for the reasons.
Thank you. All right. It's now 1:10. I suggest that we take some respite and pick up again at 20 to 2, if that works for everybody.
It certainly works for us, my lady.
Thank you. Thank you very much.
It also does work for us, my lady.
Thank you to all counsel. Let's then adjourn and pick up at 20 to 2.
Thanks,
You're excused for now. Thank you.
As my lady pleases.
It is case number 35599 of 2022. It is the matter of Prince Mbonisi Bekithemba Bhekuzulu and 12 others, and Prince Misuzulu Zwelithini Zulu and 13 others.
Yes, my lady, I'm ready to argue.
Yes, I'm ready to hear you, counsel.
As the court pleases, my lady, I confirm that I am appearing here together with my learned colleague, Advocate Mubangwa. My name is Marumo Moerane SC.
Yes.
There she appears in all her glory. Yes. My lady, we shall be brief, particularly because our learned colleague, the Donsela SC, has dealt with some of the issues that we intended raising. But we shall actually deal with three issues. Firstly, the issue that the application is not urgent, as we are in urgent court. And secondly, my lady, that some of the relief sought in the notice of motion is not competent. And thirdly, that the applicants, in fact, I hesitate to say applicants because they really substantially is only one applicant here. The others have not filed any supporting affidavits. But for purposes of form, I shall refer to them as applicants. Applicants have not met the requirements for an interdict, whether it be interim or final. Now, starting with the issue of urgency, lady, this is one of the strangest cases one has come across, because the last time one sees the word urgent or urgency is in the notice of motion at paragraph 1 of the notice motion, that the matter be heard as one of urgency, and that the applicant's non-compliance with this honorable court's ordinary rules for service, form, and time period be condoned. That is the last we hear about that. One can troll through the founding affidavit, all 155 paragraphs of it. You will not find any word or sentence dealing with urgency. So Rule 6, sub 12, particularly B, we submit has not been complied with at all. In other words, the applicants have not set forth explicitly the circumstances which is averred render the matter urgent, and the reasons why the applicant claims that the applicant could not be afforded substantial redress at a hearing in due course. The applicants have tried to raise the issue of urgency in their heads of argument for the first time, and that appears, lady, at case lines 014, 32, page 32, paragraph 99 up to 102. They attempt to indicate why they maintain that the matter is urgent, assuming that they have done so. But what is blatantly and clearly lacking here is the other leg of Rule 6.12b. In other words, they have not explicitly stated the reasons why they claim they cannot be afforded substantial redress at a hearing in due course. We submit, lady, that is fatal to an application which is brought on an urgent basis. And we submit, in fact, that they have an alternative remedy, and they may be afforded substantial relief in a hearing in due course. In fact, they've started that hearing, which is the review application which they have brought. Lady, we submit that the urgency on which the applicants are relying is at best self-created and does not constitute acceptable urgency for the purposes of the rule. We submit that the deponent to the founding affidavit, that is Prince Mbonisi, was the 7th respondent in an application before the court in Zulu versus Mate. In those proceedings, the court noted in relation to Prince Mbonisi that in another case, which is Prince Mbonisi Bekithemba Zulu and Prince Misuzulu and others, case number 10879 of 21, he sought to interdict the coronation of King Misuzulu. The court in those proceedings declined to grant the urgent relief sought and adjourned the matter and directed that it be heard together with the applicant queen's and applicant princess's applications. In Zulu versus Mate, the court found that there was no impediment to the recognition of King Misuzulu as king of the AmaZulu kingship because he was nominated by the royal family at its meeting on the 14th of May 2021. The court's judgment in that matter was handed down on the 2nd of March 2022. We submit, therefore, milady, that it was open to Prince Mbonisi to institute urgent proceedings, interdicting the president from recognizing King Misuzulu as king of the AmaZulu kingship after judgment was handed down. However, no such application was ever filed. The president recognized King Misuzulu as the king of the AmaZulu kingship on the 16th of March 2022, and a government gazette was issued on the same day. This was the second opportunity for at least Prince Mbonisi to act urgently to attempt to stop a coronation. It's common cause that the applicants launch review proceedings on the 5th of April 2022, challenging the president's decision to recognize King Misuzulu as the king of the AmaZulu kingship. That application was not accompanied by an application interdicting anyone from taking further steps or having any ceremonies as a consequence of the president's recognition and the gazetting of that decision. There's no explanation at all on the papers why the coronation was not interdicted sooner. The president dispatched and served on the applicants the record of decision in terms of Uniform Rule 53(1)B on the 10th of May 2022. That is common cause. Now, in terms of Uniform Rule 53(4), the applicants were thus required to deliver their amended notice of motion and supplementary affidavit on or before 24 May 2022. I say, my lady, that it is now common cause that this was done, but in their founding papers, the applicants denied that the record had been filed. And this denial, my lady, is found at case line 001, paragraph 102 to 103, page 61 to 62, and also at page 76, paragraph 146. Now, at the time of preparing these heads of argument, that is 2 months later, applicants have not yet delivered their amended notice of motion and supplementary affidavit. They undertook to file a supplementary affidavit on the 15th of July, 2022. It has yet to be filed. Now, we mentioned, lady, that in the matter of Juta and Company versus Legal and Financial Publishing Company Limited, the court held, amongst others, that there is, and we've put up this decision in our heads, there is such a thing as the tyranny of litigation, and a court of law should not allow a party to drag out proceedings unduly. Lady, this is at case lines 012, page 12, paragraph 35. In this case, we are considering an application for an interdict indentelated, just as we are in this case, my lady, which from its very nature requires the maximum expedition on the part of an applicant. And we cite the reference to the case, Lord. And we will submit in the next paragraph that passage was cited with approval by the SCA in the matter of National Council of the SPCA versus Openshaw. Unfortunately, lady, the citation there is slightly wrong. The correct citation it should be 2008 brackets 5, not 4, but brackets 5, SA 339. But not only was that passage cited with approval the SCA, it was also cited with approval by the Constitutional Court. Lady, we don't have that citation in our heads, but I'll provide it to the ladyship. In the matter of Cloete, CLOETE, versus S, and this is reported in 2019, volume 4, SA, at 268, Constitutional Court, at paragraph 56. It's exactly the same citation as appears in the Openshaw case. Now, we submit, lady, that it is clear from the applicant's inertia in moving the review forward that there is no particular urgency. It seems that their strategy is to obtain the interdict and then adopt a supine strategy with regard to the reviews so that the status quo can continue indefinitely. So those are our submissions, lady, with regards to the question of urgency. Now, dealing with the prayer 4.1 in the notice of motion, we submit that that prayer is not competent. I seem to believe that the learned colleague for the applicants conceded that that relief is incompetent. But in case I'm wrong about that, I'll just make a few submissions. See, in that prayer, the applicants seek an order declaring that pending the final determination of the review application in this court, and not before your ladyship, but in this division, okay, and the proceedings in the Supreme Court of Appeal for leave to appeal against the judgment and orders of Madondo DJP, and I quote, Prince Misuzulu Zwelithini is not to be regarded as the lawfully appointed and recognized king of the Zulu kingdom. In other words, they are asking your ladyship to issue that declaration that King Misuzulu, although they refer to him as Prince, is not to be regarded as the lawfully appointed and recognized king of the Zulu kingdom. See, we submit that it's not open to the court to make such an order. This court, the Supreme Court of Appeal and the Constitutional Court have repeatedly held that decisions are binding until they are reviewed and set aside by a competent court in proceedings for judicial review. This is a tried legal principle. And we refer, my lady, to the locus classicus of that odicral. I'm not going to read it out. Your ladyship is familiar with that. And these particular, my lady?
I said, yes, please. Thank you.
as the court. Yeah. These proceedings are not for the review and setting aside of the president's decision to recognize His Majesty King Misuzulu as the king of the AmaZulu kingship. Their merit and demerits notwithstanding, these proceedings are for an urgent interdict pending the determination of the proceedings launched by the applicants for the reviewing and setting aside of the president's decision to recognize the first respondent as king. It is therefore, we submit, not competent for the applicants to request such an order for this court, or for this court granted. Now, to the extent that it may be argued that this court has a discretion to grant the declaratory sort, we submit that as these are motion proceedings, considering all the relevant circumstances, this is not an appropriate case in which to exercise the discretion in favor of the applicants. Amongst other reasons, we say that although the matter is the subject of an application for leave to appeal and a review application, the first respondent has been found by a court of competent jurisdiction, that is by Madondo DJP, to be the rightful heir to the AmaZulu throne. Moreover, that particular judgment, to which the learned colleague for the applicant has referred, it concludes that there was no basis for interdicting the process leading to the recognition and coronation of Prince Misuzulu. What confounds the matter even more, lady, is that there are real disputes of fact between the parties. And under the circumstances, and without prejudging the outcome of either the appeal process or the review application, it would be wholly inappropriate for this court to issue a declarator on the central issue with which the appeal and the review courts will be seized. The fact of the matter is that de facto and de jure, the first respondent is king and has been recognized as king. And it's only in the review proceedings or in the appeal that that decision may be set aside. Actually, only in the review proceedings. Now, I shall then deal briefly, Milady, with prayer 4.3 of the notice of motion, which we submit is not competent. In prayer 4.3, the applicants request this court to grant an order interdicting the president and the minister from authorizing any expenditure or taking any decisions in terms of Section 23 of the Traditional Leadership Act to offer any administrative and financial support to Prince Misuzulu insofar as the support is given on the basis that he is Bayet. Now, we submit, Milady, that such relief is misconceived, totally misconceived. One has only to look at Section 23 and look at its provisions to see that the court cannot grant this relief because Section 23 does not deal with the king at all. In fact, Section 23 deals with support to royal and other councils. It does not deal with support to kings or queens. The Act defines a kingship or queenship council as a council contemplated in Section 16. Because that is a very lengthy section, we do not think it's necessary to replicate that section. But what we do want to point out is the difference between Section 16 of the Act and Section 8 of the Act. Say Section 8 sets out the process for the recognition of a king or a queen. It does not deal with the question of support for a kingship council. We submit that there's nothing in Section 23 that suggests that the president and or the minister are empowered to render support to a king or a queen per se. As stated above, the said section deals only with measures, including the provision of administrative and financial support by, among others, national government that may be necessary to support and strengthen the capacity of inter alia kingship councils, not kings, to strengthen the capacity of kingship councils to fulfill their functions. The applicants have not made out a case for interdicting the national government from adopting legislative or other necessary measures to support and strengthen the capacity of the AmaZulu Kingship Council. We submit that such an order, if granted, would not only be in direct conflict with the provisions of Section 23 of the Act, but would have adverse effects on the functioning of the AmaZulu Kingship Council. We further submit, Milady, that the AmaZulu Kingship Council has a legal interest in these proceedings and ought to have been joined. That the council ought to have been joined in these proceedings is trite. And we refer to Uniform Rule 10, and we also refer to the SCA matter of the Judicial Service Commission and another versus the Cape Bar Council and Absa Bank Limited versus Nodia, also a Supreme Court of Appeal decision. We further submit, lady, that it would be unlawful actually to interdict the president and the minister as part of the national government from adopting such measures as may be necessary to support and strengthen the capacity of the AmaZulu kingship to fulfill its statutory functions, including the provision of administrative and financial support. In any event, we conclude, Lady, by saying that no case has been made out for invoking the provisions of Section 23 of the Act. Finally, we deal with the requirements for an interdict, and we submit that those requirements have not been satisfied. It is tried, my lord, but my lady, I beg your pardon, my lady, that in order to obtain an interim interdict, the applicants must demonstrate that they have a right, even though it may be open to some doubt, and B, that there is imminent harm to that right, and the harm cannot be repaired, and thirdly, that the balance of convenience favors the granting of the relief sought, and fourthly, that there is no other satisfactory remedy. Now, starting with the last requirement, we submit that it is clear that the applicants have an alternative remedy. In fact, they have brought an application for the reviewing and setting aside of the decision to recognize King Misuzulu as the king of the AmaZulu kingship. This observation matters because although clothed in the garments of an interim interdict, the relief that the applicants seek is in fact final. The paragraph that we have referred to in the notice of motion 4.1 is telling, in other words, that the applicants seek a declarator that King Misuzulu is not to be regarded as the king of the AmaZulu kingship. Although the declarator is sought pending the final determination of the applicant's review application and the appeal judgment orders in Zulu versus Mate, it is final relief in substance. And we say it impermissibly anticipates or forecloses a favorable outcome in the review and in the appeal. Because the applicants seek a final interdict, we submit that they ought to have set out requirements of a final interdict. And at the forefront of that is the establishment of a clear right. And we submit that none has been established. Alternatively, to the extent that the application is truly for an interim interdict, then it is defective for a number of reasons. King Misuzulu has been king for the past 4 months, and there's been no catastrophe or harm within the AmaZulu kingship or in the province of KwaZulu-Natal. And the applicants do not point to any. Secondly, the applicants do not set out what their right is and the basis of that right. And we finally submit, my lady, that the balance of convenience favors the refusal of the interdict. My lady, those are our submissions, and we submit that the applicants have not met the requirements for an interdict. The relief they are seeking in the notice of motion is incompetent, and the applicant is not urgent. So we ask your ladyship to either strike the matter off the roll with costs for lack of urgency, or dismiss it with costs. And in our case, with the costs of 2 counsel.
Thank you.
Those are some.
Thank you.
Thank you, Malay.
I'm going to now call upon the counsel for the 5th respondent. Am I correct?
Yes, my lady.
Okay.
Thank you very much, my lady. My lady, something very unusual is happening in these proceedings where the youngest of all is going to be the one that wraps up the debate on an issue. Culturally, in our culture, it does not happen, but I will accept it.
And Mr. Matebese, you promised to be brief.
It makes it very difficult indeed for somebody as young as me to speak after Mr. Madonsela and Mr. Mwerane. So I'll try to be very brief.
Thank you.
My lady, we take the first issue, which is the issue of urgency. We have referred her ladyship to paragraph 64 of the Mogalakwena judgment, which is a 2016 volume 4 SA 99, where Tuchten J states that if it seems to me that when urgency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at a hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. I'm not going to go further in that. We say in the papers before her ladyship, no attempt has been made to address that part of Rule 612. The applicants have not said anywhere that they cannot obtain substantial redress at a hearing in due course. They have not given any reasons why they believe that they cannot do so. So we submit that on the authority of that Mogalakwena judgment, the applicants have failed to establish urgency. They do say in their papers that what they say is that the event is on the 13th of August, 2022. The problem with that is that on their own version, in their own papers, they do not state clearly who has determined that date and when was it determined and when was it brought to their attention. Because if you look at paragraph 96 of their founding affidavit, paragraph 96 would be found at 001-58. What they simply say in that paragraph is that in the recent past, they have come to know that there is a coronation committee that has been established, and the coronation committee is moving forward with the arrangements for the coronation to be done. But they say it is unknown to them when is the coronation going to be held. That's what comes from the applicants. And if one then has a look also on the documents that they seek to rely on, HRM 7 to HRM 9 in their founding papers, it is clear that this issue of the coronation is an issue that has always been debated from the 17th of March, 2022, when the first respondent was recognized, to the extent that it was first scheduled for the 28th of May, 2022, according to the documents and the communication between the presidency and the royal family. Now, the applicants are not telling her ladyship what they have been doing all this time. They are quiet in that regard. There's nothing that they are saying. They want this court to accept without any explanation, without any case having been made, that the matter is suddenly a very urgent matter that needs the court to allow them to jump the queue. We submit that cannot happen. It is not what Rule 612 is meant for. The applicant is expected to explain what he has been doing, which the applicants have not done in this case. So we submit, my lady, in line with the submission made by the first respondents and also the third and fourth respondents, that this application deserves to be struck off the roll with cause for lack of urgency. Then getting to the merits of the matter then, the relief originally sought against the Premier, which is the fifth respondent, in 4.3 of the notice of motion. I say originally because the applicants now seem to be adjusting their sails towards the wind. What they are doing, they are latching on what has been said by Prince Buthelezi, that the Premier under Section 17.5 is the one that organizes the coronation. That's what they say. But that's not the case that they had pleaded in their founding papers. In their founding papers, they specifically refer to Section 23 of the National Act to say what they seek to interdict in these proceedings is the provision of financial assistance and administrative assistance to King Misuzulu on the basis that he's a Bayed. That you cannot find in Section 23, as Mr. Mwirana has stated. You do not find that in Section 23 of the National Act. Now they want to change their case, the applicants, and peg it on Section 17.5. But there's no such allegations in their papers. They are expecting that the fifth respondent is going to respond to what Prince Buthelezi is saying. That is not what happens in our adversarial system of litigation. Our adversarial system of litigation says, applicant, make out your case in the founding papers so that the respondents are able to respond to. No respondent has got an obligation to respond to a case that is made by a co-respondent in proceedings in our system of litigation, because the party that brings all the respondents before court is the applicant, and it is the applicant that must make a case. But in any event, we submit that that allegation is based on a misinterpretation of what is in paragraph 32 of Prince Mangosuthu Buthelez's affidavit. What Prince Mangosuthu Buthelezi says in paragraph 32, he gives his own understanding of his own view or opinion of the response from the president. Because the president says in his response, when he is asked about his attendance at the coronation, he says, no, I'm invited there. He says, firstly, I've been advised by the royal family that they are hosting a ceremony. I've been invited there. In the national legislation, there's no provision for such. There's nowhere where the president says it is the premier that is organizing the event. And Prince Mangosuthu Buthelezi simply says in paragraph 32, the president was correct in my view in saying that events of this nature are organized in terms of section 17.5. But that is not an indication that the premier has indeed, and as a matter of fact, organized a coronation event. Because if one can look at HRM 7, 8, and 9, what is common in those documents is that the coronation is organized by the royal family and is hosted by the royal family. It has nothing to do with the premier. And there's no document before you that suggests that the premier has done any effort to invoke the provisions of section 17.5 of the KZN legislation. So in essence, my lady, what we submit to your ladyship is that the issue of section 17.5 does not even arise in these proceedings. And it is not an issue that is available to be pursued by the applicants in this matter. The matter should simply be confined on what they have pleaded in relation to section 23 of the National Act. And we submit in that regard. The order that they seek is misdirected and it is incompetent. For the first reason that the finding under section 23 is meant for kingship councils, which are statutory entities established in terms of section 16, that carry functions in terms of section 19, that funding is meant to assist them in an effort to carry out those functions in section 19. So if this court is going to interdict, if this court is to interdict the premier, then from granting that financial assistance, the party that is affected is the royal council, is the kingship council, and not the king. And the kingship council, for effect, is not a party to these proceedings. So how do you grant that order in these proceedings? This court cannot. That's the submission we make. One, it is incompetent. Two, it is based on a misinterpretation of section 23. And three, even if the court were to consider granting that order, there is a party that is going to be adversely affected by that order, which is the kingship council. That is not a party to these proceedings. So for those reasons, this court cannot grant the order sought in prayer 4.3 of the notice of motion. So those are our submissions, my lady, in regard to this matter, unless her ladyship has got some other questions.
No, nothing, Mr. Matebese. Thank you very much.
Thank you, my lady.
May I invite counsel for the applicants to reply?
Thank you, my lady. My lady, I will attempt to be, in fact, I have to be brief in my response. The first question, I'm going to deal with the submissions made in their sequence. In other words, I'm going to deal firstly with issues I take issue with in relation to the submissions made by my learned friend, Mr. Matonsela. And then I'm going to deal with the certain issues, not all of them, but certain issues made in response to the other two of my colleagues, including my senior leader, Mr. Morane. My lady, the first thing, this case, it's clear when your ladyship listens to the respondents you are invited, my lady, to decide this case on technicalities. You are invited to nitpick and to find the word agency, not the facts. If there's no word agency, then you can't say there's agency, even though itself is clear. The issues on the facts on which the coronation relief is sought, there's clear-cut agency. My lady, my learned friend, starting with Mr. Matonsela, my learned friend tried to suggest strongest point, which is that there are certain omissions that the applicant made, and went as far as suggesting that there was lies told and all that. I don't want to descend to that level of suggesting that even something that could be regarded as an error is wrong. What Mr. Matonsela cannot say is that Prince Mbonisi brought an application in December, in terms of which he sought to stop the coronation event that had been announced during that time, or at least that was being reported in the media. And the judgment of Madondo refers to that. So the error in the letter that is put up here is an error that should not suggest that he lied about it. It's simply an error. It's clear this letter is the 20th of January 2022, and there is a letter which was written, and it doesn't disclose that, but there is a letter written to Prince Mangosuthu Buthelezi, specifically asking him in relation to the case that was brought in December 2022. But the issues should not be resolved around that. My lady, the copious or the attempt to drag your ladyship into looking at minutes of meetings is wrong. You are not determining the review application or the merits of the review application. What you are looking at is, in light of the date of the coronation being set for the 13th of August, is there a basis on which the applicants have made out a case that an interdict of that process should be done? And my lady, I put it no further than to say that the date once announced, and you'll see in December there were rumors that a coronation would be done. That turned out not to be true. And then there was another date sometime in June, that was June or July, where coronation was supposed to be there. There was a postponement of that date. And so once that had been postponed, there was no basis to bring an interdict of the coronation. And then, my lady, the second issue that appears to loom large in the arguments of the respondents is that we have not shown substantial redress, that we will not get substantial redress in due course. And Mpepu case is cited as authority to support that submission. With respect, my lady, the target of this interdict is a coronation event. It is not the identification or the recognition position. The recognition and the identification stages are subjects of a review application. What is being sought to be interdicted is a coronation event. What remedy do we have in the event this coronation takes place? We don't have any remedy. It's like suggesting my learned friend runs away from the issue of building cases. It's like saying, well, look, I mean, you've got redress, you can have this building demolished, so why bring it on an urgent basis when it's already third floor? That's not how judges exercise their discretion when they look at the question of urgency. The question of the point of the matter is that there is an event, very important event, from the opposition we're facing right now, my lady. You know that event of coronation is significantly important in the life of the Zulu people and the Zulu nation. It's a very important occasion because that's the date on which the public is formally introduced to their king. And that is the date when all events on that occasion are directed at enhancing his stature as the king who is universally accepted as the king of the Zulu nation. So it's a significant building block in this building. And to try and suggest that we could have brought this application to review coupled it with an interdict interdict the coronation. Yeah, well, my leader, Mr. Morane, would have done that perhaps. The applicants wanted to target in the review application the identification and the recognize. Those are steps that had already been taken. So the only way to do it is to bring a review application. It's there, but it does not that issue does not ring fence the rights of the applicants to a coronation of a king who has been recognized lawfully in terms of the identification and the recognition processes that we're talking about. Then coming to well, perhaps I should just finish the issue of substantial address as dealt with by on behalf of all the respondents. Mr. Morane says that the manner in which this application has been brought is an attempt or a supine strategy. It refers to a supine strategy, which is designed to slowly challenge. I mean, to ensure that the status quo continues indefinitely. In the replying affidavit, they would have seen that the applicants are quite happy to have an expedited review application if that is what is required. So there is no idea of trying to slow down the process so that there is endless gain. There is no gain in dragging these processes further than they are. So what if for example parties are quite happy, all the parties are happy to have this review application expedited, there can be an agreement on the parties, and I put it to them that if that is what they would want us to do, we're quite happy to have truncated timeframes for the review application to be heard in the next 2 months or 3 months. There is no attempt to drag this issue indefinitely, and certainly this application was brought by the fact that the coronation date was announced in the middle of July. That is the only basis on which this in the middle of June. That's the only basis on which this application to interdict the coronation was brought. It is not a stratagem to do anything other than to ensure to protect the rights of the applicants to be full members of the royal family, participating in the activities that relate to the installation of their king, as they have set out in the affidavits. My lady, there is no interdict against royal king councils, so that issue doesn't really make any issue. There is no catastrophe since King Misuzulu has been on the throne. That's the argument being brought. My lady, the catastrophe is seen. There is an application pending in the High Court that suggests that his position has not been lawfully obtained, in the sense of he has not been lawfully recognized, he has not been lawfully identified. The catastrophe is self-evident. If his Prince Misuzulu Zwelithini is not appointed lawfully, or if King Misuzulu Zwelithini is not appointed lawfully, then the catastrophe to the unity of the kingdom is self-evident. Because how to undo this kind of problem, particularly in circumstances where your ladyship has seen in the affidavits the very emotive languages that are exchanged between the parties. The chances that this can be resolved in any other way other than a court is wishful thinking. My learned friend, Mr. Matebese, says we haven't explored the date of the 13th of August. Well, Mr. Matebese knows none of the respondents have denied that the 13th of August is the date of the coronation. So his suggestion that we should somehow prove the the announcement of the date of the 13th as one which on which the coronation is taking place is declined. It's clear on the papers that all the parties agree that the coronation event should take place. My lady, you hold a discretion that will either stabilize the disputes that the royal family, biggest royal family in South Africa, is facing. Your ladyship could just ignore what the applicants are saying to you about their involvement or their issues by dismissing this on technicalities and saying that they should have been an extradition dating as far back as when the matter was first announced or whenever. But my lady, the issues will not go away. You will have simply passed the buck, as we would say, to the review court. The coronation is not a subject of a review. Coronation is not a subject of a review. It can only be a subject of an interdict, because that's the only event that will entrench the current status quo and ensure that the Zulu nation bow in reverence to their king when he is presented to them as the only unrivaled king of the Zulu kingdom. So in summary, my lady, we have shown that the matter is urgent and it's technical. It's too technical to suggest that one should have dealt with it in the founding papers as a topic when the facts are set out in the founding affidavit. It's clear on the founding affidavit that they are claiming urgency, and what really sustains the claim of urgency are the facts. There has been an announcement made publicly that coronation is taking place. That means the urgency. The rights are self-evident. These are members of the royal family who have been excluded in participating, or have not been enabled to participate as members of the royal family in who becomes a king. So, my lady, those are the submissions we make. We ask, my lady, that, and I accept that as I have, that there are certain orders we're not going to persist with. If the ladyship is minded to give an order, it would be really in terms of paragraph 1, 2, 3, and 4.3 and 4.4 and 4.6. Sorry, 4.7 and 4.9 and 4.10. Those would be the orders we seek. So essentially, they are orders directed at the coronation event, and that's really the main issue. We would ask that you grant that relief, my lady, so that the process of appointing a Zulu king includes everybody who must participate in that process.
Thank you, Mr. Masuku. Thank you to all the council who participated. I will return a decision at exactly 3 o'clock. Thank you. You may not need to reappear. Thank you very much.
Thank you,
all
my lady.
council are excused who participated in the matter. Thank you.
Thank you, my lady.
Thank you.
But I think we'll hang around to hear the ruling.
All right. Okay.
Oh, me too. And our clients are online, and they're really anxiously waiting the article.
Okay. Thank you. You're excused for now, but if you want to keep connected, you're fine. That's still okay.
Yes,
Thank you.
As my lady pleases. Thank you.
Thank you. You're excused. Thank you. Ms. Registrar, let's just move to the next matter, please.
Thank you, Judge. Let me see. Recalling, Mr. Marwesha, in which matter are you appearing?
Yes. We're appearing on matter number 29, if I'm not mistaken, my lady.
Matter number 29-006322.
Yes, my lady, it's this matter.
Yes, my lady.
Appear
Okay.
for the applicant.
Okay.
Currently.
All right.
The leadership has directed us earlier on in the morning to try and talk about this matter. Indeed, we appreciate your indulgence. We have spoken, and by agreement that the matter will be withdrawn from the roll, the parties will then engage into negotiations in terms of the Children's Act. The leadership would have seen that the attitude of the applicant is not to seek any cost order in this matter because it's a matter that involved the minor child. But we didn't agree in terms of the cost. The respondents are persisting that they should be given costs. So we have agreed that we will leave the issue of costs in your hand, my lady. My view is that the urgent court as like this would not be capable of now saying let's argue the cost as packed as it is, but we'll leave it into your hands. Hence, I won't deal with the merits or the demerits of the matter, my lady, because there is an agreement in terms of the withdrawal thereof.
Mr. Cohen,
thank you, lady. As applicant, lady, it came as as a respondent, I apologize, lady. It came as some surprise when we learned that the applicant intended to withdraw its application. And the only issue which we cannot reach consensus on is whether my client, as the respondent, is entitled to the cost of the application. Now, my lady, your ladyship no doubt has had an incredibly busy day today. I'm going to try and be as quick as possible. My lady, the provision is very simple. In terms of Rule 41, if a party withdraws an application, costs would follow the suit, save and accept unless the court orders otherwise. Our contention with respect, lady, is very simple. What we say is that the entire application was an abuse of process. We submitted as a preliminary point, ignoring the merits which are now of no consequence, that the applicant waited 14 days to bring an application, which we submit is an abuse of process. In terms of, with respect, a discombobulated notice of motion, because it doesn't define between Part A and Part B in the ordinary course, in compliance with the rules of Court Rule 6 and the Practice Directive. We submit to ladyship that a period from the 4th of July, when the applicant acquired knowledge, until the 18th of July, to proceed with the application in a manner which he did constitutes an abuse. Your ladyship will see from my heads, I don't know if your ladyship has had the opportunity of looking at them. They were sent to your ladyship last night.
It was emailed, yes, I read it.
Thank you, my lady. That helps me. I've really set out my contentions in there. My lady, we have a position where the applicant, with knowledge of the existence of proceedings in the Johannesburg Family Court, knowing that that court has jurisdiction, has sought, in effect, to vary a court order of the family court. The proper procedure, the correct forum in which the applicant ought to have proceeded, even if it was urgent, was in the Johannesburg Family Court to ask for variation to the agreement of the parenting plan. And the Magistrates Court has the rights, as in its amended form from a few years ago, to hear urgent matters. So the correct court for the applicant to proceed was in the inexpensive family court, where no representation is necessarily required. In this case, the applicant, who seems to be a well-mannered man, brought an application against the respondent who does not have the finances at her disposal, who's struggling to maintain her own child, who's had to find alternative accommodation, which existed prior to the disclosure on the 4th of July. We know there's an agreement of lease. The respondent, I'm instructed, is in occupation of a new premises, no matter what the applicant contends. And the waiting of some 14 days is inexcusable. The respondent's only response, explanation, as your ladyship will see from the practice note in the heads, is that he didn't act expeditiously because he had to make arrangements for the child to go to school. Well, he provides no evidence in that respect. One would assume that a prudent father, prudent litigant, faced with facts which he contends that the respondent was now squatter, which of course is false, would have brought an application there and then. If he was worried about his child living on the street, which he never was, he would have brought an application on the 4th of July. He waited until the 18th, no prior demand to the respondent, as one would have expected from his attorney. He brings an application in the High Court with the huge incurrence of substantial legal costs, having to employ an attorney and counsel, and then withdraws the application because he obviously realized that there's no merit in what he has done. The correct remedy, Johannesburg Family Court, there's a maintenance court proceeding. The entire application was a flagrant abuse of process. I'm not going to say how many urgents, etc., I've been in the years I've been in practice, my lady, but the general approach to urgency is set out by our case law. There's a judgment, the judgment of Justice Coetzee then many years ago, which is followed and is dealt with in Erasmus, is dealt with in the New Herbst and Van Vincent, and the principles are clear. Do not abuse the court process if you're going to bring urgent, unless in the absence of commercial urgency, it's a matter of life and death. If there was a matter of life or death that existed on the 4th of July, to wait 14 calendar days, 2 weeks, to be spurred into an application without a prior demand warrants, in my submission, the striking off of the application from the roll. And if the matter were to be argued, in notwithstanding the now withdrawal and the provisions of Rule 41, I would have attempted to persuade your ladyship that the correct order would be to strike the matter from the roll with punitive costs. And the reason being, my lady, is that the child is no longer with the applicant. He returned the child to the respondent on Sunday evening.
Thanks, Mr. Khan.
Thank you, my lady.
Thank you. Mr. Mahoshi?
Yes, my lady, let me respond to that. First, let me identify that the matter is withdrawn by agreement. It's not because that the applicant had intended to withdraw the matter. That is not the correct version of the applicant. I hear my learned friend has been putting that to you. The ladyship, if we recall earlier in the morning, had issued a directive to us to try and talk about this matter. That's what we did. It's not that the applicant had intended to withdraw the matter. The other issue that my learned colleague is now traversed with, which touches the merits of this matter, is that the ladyship would know better that this court is the upper guardian of the minor child, and it's got inherent jurisdictions to deal with matters that are urgent. If the ladyship have regard to the papers, what brought this matter before the ladyship, it's simply that there was a clear admission under oath by the respondent during the maintenance proceedings that she was evicted, my lady. On that basis, it was difficult to understand where the minor child will be residing with the respondent when she had made it clear under oath. She's not even denying it before you in her answering affidavit. Before you, she simply says that she made a mistake before the maintenance court under oath because English is not her first language. She was not evicted. But that doesn't hold water because the respondent understands clearly the difference between eviction and termination of a lease agreement. That's what brought the applicant before this court to say that the rights of the minor child in this respect, more so the safety of the minor child in respect, should be secured, and the applicant should be given a temporary residence of the minor child be vested in him pending the respondent trying to get herself into order and the matter be referred to the family advocate. The issue of the lease agreement that has been placed as an annexure before you, that has been brought before the court, which was never brought before the applicant, who is the person who was handed over the minor child when the respondent realized that she was indeed evicted, is that lease agreement, he's been admitted by the respondent under oath in the answering affidavit that it's invalid because she says it's not complete. Now, we can't rely on that lease agreement. Hence, I'm saying to the ladyship that we have hit to your call to enter into negotiations. And the fact that the minor child now is with the respondent, it's well known that the respondent had gone to fetch that child. The applicant could not resist because in our papers we've stated that previously the respondent has done that with the police. Now, the applicant had indicated to us on Sunday that the respondent is there to fetch the child. We advised him as his legal representative that hand the child over because she might as well go to the police again, even though we did not know where the respondent was going with the child, because as at on Sunday, the respondent had not furnished us with any proof of address. All we knew was that the respondent had been evicted, my lady. Hence, we're saying that we heeded your call and we allowed common sense to now persist so that we can go into negotiations, my lady. And
Thanks,
our
Mr.
view,
Mahoshin.
I appreciate it as well.
I read the papers. I would have struck the application of the role, I must tell you now, because there's no substance to it. That's what happens when people don't speak to others when they have a need to. It only had, all that the applicant had to do was to discuss the matter with the applicant, find out whether she's found any alternative accommodation and not a matter that warranted running to court. I would have definitely struck the matter of the role. That's one of the reasons I encouraged that the parties speak to each other. In any event, I'm glad that you've actually reached a conclusion of withdrawing the application, but I'm still of the firm conviction that the applicant must pay the costs of the respondent. The parties are excused. Thank you.
As the court
That's
places.
the order I will make in respect of costs. Thank you.
Thank you, my lady. Maybe excuse, please.
Thank you. Yes, you're excused.
I hope your ladyship's going to have a break for a few minutes. It's already 10:23.
I will. Thank you. You're excused.
Thanks.
My lady, might I recall the matter from this morning at 8 o'clock? That's the RAF matter.
Judge,
Good afternoon again.
thank you, Judge.
Yes.
I see the text was on. May I recall the matter, Judge?
Which matter? We've just got a few minutes.
Yes.
Yes. I just need to dispose of matter number 20, and then we'll call matter number 31.
Okay, Judge, that's
Thank
fine.
you.
Thank you, Judge.